Good morning, everyone, and welcome to our webinar, Handling Employee and Business Issues During the COVID-19 Crisis. I'm Jill Zozula with LSL CPAs, and it's great to have you here with us today. We have got a ton of information, as you can imagine, so I'm going to just jump right in and get us started. I wanted to introduce our speakers today. From LSL, we have tax partner Mike Agresti. And we are so grateful to have Amy, Patton, and Jeff Brown, who are attorneys in the Labor and Employment Department at Payne Fears, presenting this information for you today. Before we get started, I have just a few quick housekeeping items, and then I'll go through the agenda. We have received an overwhelming amount of questions, as you can imagine. We're going to do our very best to answer those questions for you. If those questions weren't answered in the presentation itself, we're going to try at the end with the Q&A, depending on how long we go. So if you do have a question for us, go ahead and hover your cursor to the bottom of your screen, and a little menu will pop up, and you'll see a Q&A box. That Q&A box is where you will pop in your question. So now for our agenda. We are going to look at the latest tax updates and disaster relief loans. We're going to talk about the Families First Coronavirus Response Act. We're going to discuss safety net benefits in California for your business and your employees. We're going to go over layoffs, furloughs, and reducing of time and pay. We'll touch on employee relations and management issues. We'll go over other business issues to consider, and we'll close again, I said, if time permits, with Q&A. Last thing I want to mention is that we are recording this for you, so if you have to jump off early or you have someone you'd like to send it to, you will be receiving the link to this recording later today in your inbox. And without further ado, let's get started, and we're going to hand it over to Mike Agresti.
Thank you, Jill. Welcome, everyone. Thanks for joining us this morning. I just wanted to start off with talking about the federal tax due date delay. As I'm sure most are aware, the federal tax due date has been delayed until July 15th of 2020. And what this not only includes the filing of the tax return, but also payment of your 2019 taxes. So that would be a balance due with a 2019 filed tax return, or extension payment with the 2019 return. So if you still need additional time to file your return after July 15th, you can still file an extension, but it will only be for 3 months to get you to October 15th, which is the normal extended due date with an extension. The delay to July 15th applies to individual returns, trust tax returns, C Corp returns. It does not include partnerships, S corporations, estate and gift tax returns, payroll taxes, or excise taxes. The delay to July 15th also applies to the first quarter federal estimated tax payment for 2020. Unfortunately, the deadline for making the second quarter estimated tax payment for 2020 has not changed. So currently, your first quarter estimated tax payment is due July 15th. The second quarter estimated tax payment is due June 15th. So it's a little oddity there in regards to the estimated tax payments for 2020. Next slide, please. Oh, I'm sorry. On the previous slide, I also wanted to mention that July 15th delay also applies to contributions to IRAs and HSA accounts as well. So you do have additional time to make contributions to those accounts if you were wanting to do so for 2019. And then in regards to California, they conform to the federal tax due date of postponing until July 15th of 2020, just like the federal return. The state tax payments and the extension payments for the state are also due July 15th. But what the state did, as opposed to the federal, is that the first and the second quarter estimated tax payments for 2020 have been delayed until July 15th. So both the first and the second quarter are due at the same time. And basically, I mean, with the delay in the tax filings, we're still encouraging our clients to send in their tax information and still get us their information even though we do have the additional time to file. I just believe with everything that's going on right now, it makes sense to find out whether you have a tax liability for 2019, and then then you have that additional time to figure out a plan for making those payments. So I wouldn't say the delay should be a delay in getting your tax information in. Next slide, please. So yesterday, the Senate passed the CARE Act, and now currently it's in the House this morning for voting. But these were some of the important tax provisions that are in the act that I thought a lot of clients would be interested in knowing about. The first one is about payroll tax credit refunds. So this is in regards to the credit for the required paid sick leave and the paid family leave payroll that business owners would be paying to their employees. The IRS is in the process of creating new tax forms that these refunds would be advanced, and the business owners would be able to receive them much quicker. And the IRS is also instructing that they will waive any penalties for failure to deposit payroll taxes if the failure was due to the anticipated payroll tax credit. The next one is the employee retention credit. So the bill creates an employee retention credit for employers that close due to the coronavirus. So eligible employers are those that are allowed a credit against employment taxes equal to 50% of qualified wages, up to 10,000 wages for each employee. So eligible employers are those that were required to shut down because of order from the government or some kind of limiting of commerce or group meetings. It also includes employers that have gross receipts that are less than 50% of their gross receipts for the same quarter in the prior year. And those employers would continue to be eligible until their gross receipts exceed 80% of their gross receipts for the same calendar quarter in the prior year. So you basically would be matching your current quarter to the quarter in the previous year. And if your gross receipts are 50% or less, you would be ineligible for the retention credit, and you would continue to be eligible until your gross receipts for the quarter of the previous year exceeded 80%. So for employers with more than 100 employees, wages eligible for the credit are wages that the employer pays employees who are not providing services due to the suspension of the business or the drop in gross receipts. So it's not everybody. But for employers with 100 or fewer employees, all wages paid qualify for the credit. The retirement, and then the next one is retirement plans. So taxpayers can take up to $100,000 in coronavirus-related distributions from retirement plans, and they would not be subject to the 10% additional tax for early distributions. Eligible distributions can be taken up to December 31st of 2020. These distributions can be repaid within 3 years. And then for purposes of these distributions, the eligible taxpayer is one who has either been diagnosed with COVID-19, is caring for a spouse or dependent who's been diagnosed with COVID-19, those who experience financial consequences from being quarantined, laid off, reduced work hours, or unable to work due to lack of child care. Any resulting income from taking the distribution will be allowed to be taken over 3 years. And the bill also allows for loans up to $100,000 from qualified plans, and the repayment will be delayed. And the last one, the payroll tax delay. So the bill is proposing to delay payment of 50% of 2020 employer payroll taxes until December 31st of 2021. Then the other 50% of the payroll taxes would be due the end of December 31st, 2022. So those are just there are more tax provisions that are part of this act, but I thought those were the top 4 that business owners would be most interested in. Next slide, please. So also part of this, the CARE Act, is a portion that would be sectioning off $350 billion to the SBA to help small businesses. So what this program would enable is employers with up to 500 employees to borrow 4 months for payroll, debt service, rent, and utilities. The loan payments would be deferred for 1 year, and the payroll portion of the loan may be forgiven without tax consequences. In regards to the loan forgiveness, it will be reduced if you have a reduction in headcount or rates of pay. So in addition to what I spoke about on the previous slide about the employee retention credits, this would be another reason why, if you're thinking about laying off staff, you may want to delay on that just because of these credits available. The government is trying to do what they can to allow businesses to not lay people off and to keep them employed, and giving them these credits and these forgiveness on these loans, you know, if they're able to do so. In regards to the debt service, it would be debts that were incurred before March 1st of 2020. It's unclear right now what the interest rate will be and if the interest during the deferral period will be forgiven. Now, there also is, under the SBA program currently, there is the disaster relief loan, but you're only able to receive a loan from either the one under the CARE Act or under the disaster loan. So taxpayers cannot take a loan from both programs. So right now, what we're telling our clients is, if you've applied for a disaster loan, we're recommending that they hold off proceeding with that until we get more information about the CARE Act, and hopefully this will be passing here the next day or so. And because what's available under that program would be a lot better for them than the one under the disaster relief loan. And that's, I think, Amy, it's up to you now.
All right, thank you. Thank you all for being on here today. We've got there's a lot of complicated terms and if this but that thrown at you throughout this presentation, and I know it's confusing. I can tell from the questions that people ask. We got to preview that you know, our audience is confused, our clients are confused, and we're a little bit confused too. So we're all in this together. Let's see what we can figure out here. So on March 18th, President Trump signed the Families First Coronavirus Response Act. This is effective on April 1st, and it expires by its own terms on December 31st this year. For employers, the act does 2 things. It contains an emergency paid sick leave act, and separately, in a different law, it contains an amendment to the Family Medical Leave Act. It expands it temporarily. First of all, if I were you, I'd want to know if I have to provide these benefits. Am I subject to this law? And I think everyone on this call probably is. It applies to employers who have who employ fewer than 500 employees. There is some relief from the provisions of this act for some employers with less than 50 employees. The Department of Labor is going to be putting out some guidance by the middle of the month on how to take advantage of that relief. This is a little bit different from, the way that you usually see employment-related laws written. Normally, you have to be of a certain size, or you have to work for so much time before you can take advantage of a benefit. But for the purpose of emergency paid sick leave, anyone who is employed at a covered business is eligible for this type of paid sick leave. You only need to meet the criteria for the purposes of the leave. So under what are the purposes, there's a lot of confusion about this. Make sure. There are 3 situations in which an employee is covered. One is if the employee has been ordered to self-isolate or quarantine because the employee is diagnosed with COVID-19. This is probably the element that has the most uncertainty. A lot of people are reading this as meaning that the shelter in place or stop work orders are subject to paid sick leave. And it is just not true. It's very specific. The shelter in place type orders were in an earlier version of this bill and they were taken out. So this truly is a quarantine or isolation type of order. The second one is a little broader. They can be advised by a healthcare provider to self-quarantine. Or they can be, the third one is they can be experiencing COVID-19 symptoms and seeking a medical diagnosis. That implies to me that as the employer, you don't have any right to have a piece of paper from a doctor. You just have to have an employee saying, I'm trying to get in to see a doctor, I'm trying to get a test. So this is a pretty liberal standard here. In the employee situation, the paid sick leave is paid out at full wages, subject to some limitations that I'll talk about in a second. If the employee is caring for someone else, so someone that would be subject to 1 or 2 above, subject to a government quarantine or an isolation order or advised to self-quarantine, they are eligible for 2/3 of their wages in the form of paid sick leave. Note, this is not limited to a family member. The law says caring for someone else. And then the second provision is if the child's school or place of care has been closed, and I think that applies to probably everyone on the phone if you have children, or if childcare services are unavailable due to COVID-19 precautions. Now, this doesn't apply if the employee is able to telecommute or work remotely. You don't have to provide this to those employees. A few more words, actually, before I go into the Family Medical Leave Act on the paid sick leave. If you have a full-time employee, the paid sick leave is 80 hours. For a part-time employee, it's the number of hours that the employee works over a 2-week period. And there are some compensation limitations. Paid sick leave is capped at $511 per day or $5,110 total per employee for reasons 1 through 3 on the screen that you see here, and up to $200 a day or $2,000 total for an employee for reasons 4 through 6. There's no carryover of this benefit. If the employee doesn't use this leave within the 9-month period of the law, it goes away. And employees can break up the sick days. I think that was one of the questions. So it can be taken in pieces. And it could probably be taken in partial day increments too. If someone's sharing childcare with a spouse, perhaps, you might see them wanting to break up these days. This emergency paid sick leave is also in addition to any state or local mandated paid sick leave, and employers are prohibited from requiring employees to use or exhaust any other paid leave before using this leave. So this leave is available notwithstanding the fact that you might have a California compliant paid sick leave policy. So it's in addition to, you need, and if you have a PTO, some employers would prefer that the employees use their PTO before using this, but you're not allowed to mandate that. All right, moving on to the Emergency Family Medical and Leave Expansion Act. This act also covers employers with 500 or less employees. Generally, FMLA covers employers with 50 or more employees during 20 work weeks in the past year, but here it's expanded to 500 or less for this provision only. The 500 or less employees does not apply to all the other reasons that employees use the FMLA. All the rules that you already know apply to those leaves. Also, this act doesn't expand the total amount of leave that someone can get. There's still only 12 weeks under the FMLA. So if someone has already partially exhausted their FMLA, this does not increase their entitlement. Here, in order to be a covered employee, you have to be employed for at least 30 calendar days. So the eligibility standard for employees is relaxed as well. And in the CARES Act that you just heard about, which isn't enacted yet, but we all expect that it will be. If you have an employee who has been laid off, I believe since February 15th of this year, and you bring that employee back on, then that 30 days doesn't apply. They just have to have been employed for not less than 30 days in the last 60 calendar days prior to the layoff. So if you want to take advantage of some of the benefits that are in the CARES program, like the SBA loans and payroll credits, you may still be able to do that and have some of your staff come back on board so that you don't lose them. Under the new FMLA provisions, this only provides for one type of leave, and that is if an employee is caring for their child under 18 years of age because the child's school or place of care has been closed or the child care provider is unavailable due to a public health emergency. It doesn't expand the FMLA leave for any other purpose. So FMLA leave is 12 weeks. The first 2 weeks are unpaid, but the employee is allowed to substitute any other form of paid leave that they have available to them. So that includes the emergency paid sick leave that we just talked about. It also includes California paid sick leave, covers public health emergencies, PTO or vacation. They can substitute that for the 2-week unpaid portion. And then beyond that, the remaining 10 weeks is paid at 2/3 of the employee's normal wages. There are tax credits available for the payments that employers make. It's a payroll tax credit. Any kind of retaliation for the use or suspected use of these new laws is prohibited, and eventually after this crisis is over, we may see some lawsuits, in that area. I suspect we will. The employer is allowed to ask for notice, but at this point in time, it's impracticable to expect that because most of our kids are already out of school. And most people, don't really know if they're going to get COVID symptoms or not. So the notice provision may not be terribly helpful to us. The employer is required to give notice of both of these acts, and Just either this morning or late yesterday, the Department of Labor, that's the Federal Department of Labor, posted some form notices on its website. So encourage everyone to go online, get those, and get those notices out to your employees. And these bills do come out of your, the money does come out of your pocket initially. But just want to caution everyone that, for things that aren't covered under this, for work stoppages that aren't covered under this, they're probably covered under unemployment insurance. And both of these bills are, both of these acts are very clear that things that are eligible to be paid for by unemployment insurance are not to be paid for under these programs. All right, so we're going to move on to furloughs and terminations, and Jeff Brown will be talking about that.
Okay, good morning. Those on the call, can you hear me okay?
We can hear you.
Okay,
Yes.
Okay, good. Okay, so what I want to do is talk a little bit about the inevitable here. I know that everybody's focused on the CARES and some of the benefits that have been provided and the idea of small business loans. But it's simply inevitable that some employers are going to wind up letting people go, either because the business is of a nature that is just so decimated by these slowdowns and shutdowns that it simply doesn't make sense. You don't have any work for people to do, or the cash flow slows down. I've got one client who probably does qualify for some of the small business relief, but simply doesn't believe it when people say they are here from the government and they're here to help. So there are many reasons that we're just not going to be able to avoid it. And at this point, I think it's easy to forget some of the problems with a reduction in force or with a layoff under the old mundane laws that don't have anything to do with COVID-19. So what I want to talk about a little bit is the WARN Act, which is the Federal Worker Adjustment and Retraining Notice Act applicable to layoffs. Also CalWARN, which is California's parallel to that, or the Baby WARN Act. And then we're going to shift into a little bit of a strategy discussion regarding furloughs versus layoffs versus terminations, and just a reminder of some of the things to think about as you go through this. So let's talk first about WARN. As we look at sudden shutdowns here, a lot of employers are responding by letting people go, and they forget that under the Federal WARN Act, in a lot of circumstances, you're actually required to give 60 days notice of an impending separation. And so let's start with some of the definitions here. A separation means either a termination, you just let somebody go, there's no path back for them, or under the federal law, a furlough of longer than 6 months. Furlough is an interesting term. Everybody throws it around and thinks it's a cure-all, but it's not. If somebody is put off duty and is not receiving work, not receiving pay for more than 6 months, the Federal WARN Act will consider that to be a separation, and it will count toward the WARN trigger. Who is an employer under the federal law? You've got to have 100 or more employees, and we look at that broadly. We won't get into the minutia because we don't have time on who's an independent contractor or an employee here, but in general, you are looking at it broadly, and it can include part-timers if in the aggregate they're working at least 4,000 plus hours a week. So it's not, it's a fairly complex question if you're right on the cusp there, but basically this is for bigger employers, 100 or more employees. There are two things that trigger the notice obligation under the Federal WARN Act. One of them is what we call a plant closing, and that is if you permanently or temporarily shut down an entire site of employment and 50 or more employees will have a separation. So you've got one facility, It's got 55 employees there. You've got other facilities across the state, but you decide to shut that one down, and those people lose their jobs. You have now had a plant closing, and you've triggered the Federal WARN Act. The other thing that will trigger Federal WARN is what we call a mass layoff. And a mass layoff is when we look at a single site of employment. It doesn't close down, but we lose either 500 employees, period, no questions asked, or 50 employees, and the 50 is at least 33% of the workforce. So there's a couple different ways to measure that. And so when you're, and by the way, you look at this on a 30-day window. In other words, if I let go of 25 people in 1 month and 25 in the next month, I'm not really as clever as I thought, because there is a 30-day rolling window that the federal government will use to look at the layoff. So these are the things that trigger a WARN notice obligation. And a WARN notice is basically a written notice given to the employee and to some other recipients, the union, if a union is in place, heads of certain local government units and government agencies. And it goes out 60 days in advance. And if it doesn't go out 60 days in advance, then an employee can recover pay in lieu of notice for each day that you missed the 60-day target. So that liability can add up very, very quickly. So the last bullet point on this slide talks about the unforeseen business circumstances exception. That's what is the saving grace for everybody right now. It seems clear, although we don't have an unchallengeable ruling anywhere. It's too new, but it seems clear that this onset of not only the coronavirus diseases and illnesses themselves, but also these shutdown orders. These are unforeseen business circumstances. So I think that we're going to have a pretty easy time arguing, at least on the federal level, that we're going to qualify under that exception to the notice. Let's go to the next slide and talk about CalWARN. So CalWARN is a little bit different. It's the same structure as the Federal WARN Act. It's a little broader, a little more protective. Under CalWARN, for a furloughed employee, you don't have the same 6-month period. You can have a much shorter period of job loss that will equate to a separation. The threshold for coverage is 75 employees, not 100, and the triggering events are also broader. Under California law, we don't have the term plant closing, but we have the termination. And termination means a cessation or substantial cessation of operations at a covered establishment. There is no numerical threshold. So in theory, under California WARN, if you count, if you're an employer with 75 or more people, you've got a branch office with only 10 people and you shut the whole thing down, you have now conducted a termination and you're going to trigger Cal WARN. The California equivalent to a mass layoff is 50 or more employees during a 30-day period. There is no percentage threshold. So California is very simple. If it's 50 or more, or if you shut down the whole branch, bang, you're under Cal WARN. Cal WARN requires notice, just like Federal WARN Act does. You've got to give the notice to the same basic population. California, previous to this crisis, was not as developed as the federal law in terms of potential defenses. And the California statute does not have the unforeseeable business circumstances exception. So in the first few days last week of various shutdown orders coming from the county or the state, it put employers in just a logically impossible position, because on one hand they were being told shut down immediately, and on the other there was no relief from the idea that they had to have given 60 days notice, which seems absurd, and even our governor figured out it was. Let's go to that next slide. and issued an executive order relieving employers from that 60-day notice period, recognizing that the COVID-19 crisis is indeed an unforeseeable business circumstance, and apparently incorporating that into Cal Warren. So that order, the terms of it there are bullet pointed out, but the important thing here is it did not suspend Cal Warren. I've gotten a number of calls from clients, and I mentioned this, and they say, "Oh no, it's suspended. Newsom suspended Cal Warren." That is not true. Last bullet point: you still must give the notice, but you've got to give the notice as soon as practicable. So really, all that was suspended is the hard 60-day period. If you're looking at your facility today and you're thinking, "Gee, despite all these relief efforts that have been made, I'm still going to need to shut down a branch on Monday or Tuesday," you still have to get the notice out to people. It's you get a break on the 60 days, but not the overall notice requirement. Let's go to the next slide here. Actually, perfect. Move on one. So, where does this leave us as a practical matter? And so we've got a jumble of different laws, and we're trying to figure out strategically how to negotiate them. Okay, and so some of the things that pop up are, number one, we have a number of different resources available. Amy's going to touch in more detail on them, but the old provisions before the coronavirus came out are still there. So job sharing, for example, under the EDD program, in lieu of termination, you can spread the reductions around and apply for a plan to get unemployment coverage there. The furlough is an interesting prospect. A furlough is generally thought of as a time period during which an employee is not provided work and is not paid, but still remains formally on payroll. And so this is considered a termination under many areas of the law. California Labor Code, for example, considers it to be a termination for purposes of final paychecks. You can't put somebody on furlough and withhold all their accrued vacation, for example. You've got to pay it off on the day that you put them on the furlough. It is also clear that a furlough will constitute a, quote, termination under the various Warren provisions. So the question then is, under these new laws that would allow the paid sick leave and the family leave expansion, is a furlough a termination or not? And that hasn't been answered dispositively. And you can see how this gets to be kind of a twisted strategic question, because if a furlough is not a termination, and I'm putting somebody on furlough because my cash flow does not permit me to keep them employed, and they are on furlough past April 1, can they then apply for and submit documentation for the paid sick leave, or ultimately for the family medical leave expansion, and the compensation payments that would have to be made under that? And, you know, it's great to say, hey, later on I'm going to get a tax credit, but this is going to be a cash flow hit up front. And so perversely, you know, we have clients who are trying to be fair, do the right thing, take care of their employees, et cetera, by putting them on a, quote, furlough, close quote, instead of terminating them, but they may very well be exposing themselves unintentionally to these payments required under these expansion laws. So you've got to think through what the impact of putting somebody on a furlough is as opposed to terminating them. There's another common approach, which is simply to reduce pay and try to spread the misery around a little bit. And I'll jump on the soapbox quickly and just comment on how impressed I've been at many of our clients, and how their first thought is not just, hey, I've got a hoard of cash, but hey, how do I take care of my people? And they are being creative in thinking of ways to do that. One of them is reducing pay across the board to kind of spread it out. Great idea. Got to be careful, though, that that's not having unintended consequences. If you've got people who are exempt for various reasons, we've got to be careful we don't ruin that exemption. For example, if they're in the white collar exemptions and they're on a salary basis, we don't want to reduce pay below the minimum for the salary basis. Commission salespeople, obviously a very complex pay period by pay period test. We don't want to reduce pay in such a way that we mess up that exemption either. So reductions in pay are a good thing to think about, but again, we've got to look back to all the pre-COVID-19 laws. They still apply. If we are conducting layoffs, we've worked our way through the WARN Act considerations, we've got to still remember that although everybody will believe that the COVID-19 crisis probably created an economic imperative for a reduction, it did not tell us how to select for that reduction. And so certainly the anti-discrimination laws are still in place. In particular, in a reduction in force, we want to be sensitive to age discrimination claims. The OWBPA still applies, and if we're going to create an exit incentive in connection with a layoff, we still need to go through the process of creating notice, analyzing the decisional unit, all those things that applied before. We are getting a number of calls from clients who have locked in on the idea that older members of the population in general have been sort of identified as being at higher risk in the coronavirus issues, and therefore are looking to them first to either furlough or send home, and that may be supported from a medical standpoint, but it's not necessarily the right thing from an employment law standpoint. So we don't want to be triggering age discrimination claims here because we thought we were doing the right thing under the sort of conventional medical knowledge here. So there's a host of issues there in terms of a reduction in force that existed before the coronavirus and will exist now that you've got to think about. And then also a set of issues regarding whether we furlough or terminate. The other thing, and this is a perfect storm in California because, as you know, in California with AB 5 and the dynamics decision that came out before that, I feel like we just did a round of webinars on the independent contractor question. California is extremely hostile toward the idea of people being independent contractors or freelancers. And unfortunately, that seems like a great solution at first to issues that arise under the coronavirus. Hey, I can't support my payroll the way it is, but I want people to be able to work. Gee whiz, the DOT is relaxing their hours of service. Maybe the people who can work, longer hours. There's a number of creative thoughts, and one of them is take people off your payroll, make them freelancers, but you run right into California law on independent contractors. And so we don't want to suddenly take our office staff and convert them into freelancers because we think it's going to get an advantage here or allow greater flexibility in pay, and inadvertently do something illegal there that's going to expose us to a class action. So we've got to measure all the responses. I think there may be questions about this topic later, but I believe we're done with this portion of the slideshow now, so we'll move on to some of what the state is helping us out with.
All right, thank you. I have to second what Jeff said about the gymnastics our clients are going through to provide for their employees. I have been astounded at the generosity of some of our clients, how they are working so hard to put packages together to maintain their workforce, the level of worry that they have about them. And I'm sure that's the way that many of you are feeling too. But, there are situations where it can't be done. Cash flow doesn't permit it. We've dealt with restaurant and hotel employers that are in just a terrible position during this because their people can't work from home, and they have large portions of their workforce, if not their entire workforce, that has to seek out, the safety net benefits that are there for us all the time and have been modified in the present time to attempt to meet our current needs. Now, there are some things that are available for employers, and you heard already about what's happening with the Small Business Administration disaster loan assistance and what we hope will be in the CARES program, so I won't go back over that. I just encourage you all to consult with your
So Jeff, do you have a section that maybe we can jump to that you can take over for a bit while we get Amy back on? Apologies, everyone.
Sure.
Zoom and GoToWebinar just inundated now, as you can imagine, with people logging on. So I'm going to go ahead and share my screen, and you can tell me what slide to go to. Okay, Jeff?
Let's go to caption number 5, employee relations and management issues.
You got it.
And then we'll move down one. And so some of the questions that we have had deal with how do I respond to workplace issues, and we've got the range of employees who simply want to stay home because they don't want to come in at all, and to the other one, employees who wish to keep working, but we are afraid that they may actually spread something. And so on that end of the spectrum, can we require employees to get tested for COVID-19? And this is one where the current guidance, which is coming out from the Department of Labor, the EEOC, is a little bit different than you might expect. Normally, it is next to impossible to get a medical exam done of an employee. You've got to show that it's narrowly tailored to meet business necessity. So if they've got a particular lifting demand or something and we think there's an ergonomic injury, maybe we can get them in. But you can't just walk around and say, gee whiz, you look sick, I need you to go get tested. There is guidance coming from the CDC that says, though, that the spread of COVID-19 is an emergency. It is arguably a direct threat, and it is something that employers can address. And so, yes, if you do have an employee who's exhibiting symptoms of a, quote, influenza-like illness at work, you can ask them to leave, ask them to go home. Otherwise, that might be considered disability related, but under these particular circumstances, the EEOC has chimed in and said, yes, we are behind this effort. You can ask them to go home if you believe they have flu-like symptoms. Related question about, can you ask employees to have their temperature taken? Again, historically, there's no way you could go around and do this, but the EEOC has put out a guidance saying, yes, you can do that. You can require temperatures to be taken. You do have to give them notice of it. You do have to respect HIPAA rights, privacy rights, etc., but you can actually do this. So the good news, in a way, is that you can step out and be a little bit more proactive about managing the workforce than you otherwise would have been able to, because everybody recognizes the importance of this.
So just checking here if you can hear me. I've rejoined.
Good. Good.
Right.
We were just walking through some of the management issues under number 5, and let's wrap up with that one slide, management issues. We'll save employee relations for later and hand this back to Amy.
Okay. So I'm not sure where I got dropped, but I know I was talking about the employer side benefits, and what I was saying when I realized that I wasn't on anymore was that, you really should, that there's the Small Business Administration loan assistance, and everyone should consult with their tax professional sooner rather than later on that topic, because it impacts what you're going to do with your employees right now. There's also the California Unemployment Insurance Work Sharing Program. Employers impacted by COVID-19 through reductions in services or slowdowns in business may apply for unemployment insurance work sharing program. The work sharing program permits employers to avoid layoffs by reducing work hours and the wages of their current employees and partially offsetting these reductions with unemployment insurance benefits to those employees. The workers of employers who are approved to participate in the work sharing program receive a percentage of their weekly uninsurance benefit amount based on the percentage of hours and wages reduced not to exceed 60%. And you'll want to check, the EDD has set up a COVID-19 resource center. So if you just Google EDD and COVID-19, it's the first thing that comes up. But there's also a link on EDD for the work sharing program where you can get more information. One of the questions was, will we be looked down on, I think, by EDD if we don't participate in this program? I think the answer to that is no. This is a very chaotic time right now. A lot of employers don't even know about this. And I don't think anyone is going to, to punish or retaliate against you for not taking advantage of a program that carries, a good deal of administrative burden right now. There's also the America's Job Center of California Rapid Response Services. Employers facing closures or major layoffs caused by COVID-19 may request the assistance of Rapid Response Services to help their employees with job training, career counseling, and services like that. I don't know how effective this will be in this environment, but it is out there, and this is one of the entities that really gets noticed when you do your warning notices. They typically start working employees right away, a good number of employees in one area that are going to be laid off. Talked about the payroll tax deadline extension, so I won't talk about that. Payroll tax credit for paid leave. These are also just that are available to employers. And then for your employees, like I said, you want to make sure if you're doing reductions, even reductions in pay, that you direct your employees to the resources available to them through EDD. If you have someone who is ill or in quarantine due to COVID-19, they are going to be eligible for disability. Employees who are missing work due to the child's school closure, if no other care options are available, will be eligible for unemployment. And then reduced hours will also make them eligible for unemployment. The 1 week waiting period, to my understanding, has been waived for all unemployment claims right now, if the reason for the unemployment or underemployment is COVID-19 related. And then, as we talked about earlier today, there's also relief under the federal laws for employees too, in the terms of the paid sick leave and the expanded family medical leave act. Right. And then I think we're ready to go back to what Jeff was talking about when I came back on.
Sure. So let's jump ahead here. Let's go down to a couple slides down from there, the one that we had in employee relations. Okay. So the other bucket, I guess, of questions is, the first one we talked about is, what do we do relative to the employee who either wants to stay at work or is demonstrating symptoms or somehow gives us concern. And we see that we've got a little bit greater hands now in requiring some kind of medical test here, including taking their temperature. Flip around now to look at the rest of the workforce. What do we do with the rest of the workforce when we do have that situation? So normally we get very nervous, right? We don't want to talk about anybody's health situation with anybody else because of privacy and HIPAA rules. But there are a number of communications and pieces of guidance being put out by the CDC now, and the EEOC has in general backed them up. And let's flip to the next slide if we could there. And just, stay on that one, employee relations. So there's a number of communications going out. It recognizes we have to track down contact points. Okay, so if we had somebody in the workforce who does test positive, We do have an obligation. We don't have a legal obligation to notify CDC, but we do have an obligation to try to make our workforce and workplace as safe as possible, which means identifying who that employee came into contact with and then going to those people, advising them of the fact of the potential contact, and possibly sending them home. As well. So we are going to have to identify to the extent necessary when there has been a positive test or a confirmed occurrence of COVID-19. It's totally possible to do this without the name in some workplaces. In some, though, I mean, I think of our law office here, and everybody's constantly walking around talking to everybody else, and I don't think we could really say, oh, it was compartmentalized in the insurance group or something like that. So sometimes you are going to have to go ahead and identify who it was. EEOC has made a point of clarifying if you are talking about somebody who is suspected but not confirmed, or who is asymptomatic, we do want to point that out, that they are asymptomatic and that we're simply taking the precaution. So we're going to have to track down the contact points there. As far as needing to provide certain things, face masks have been asked for, hand sanitizers, whatnot. And this is kind of a rule of reason that we do need to follow not only social distancing, but also disinfection, cleaning of the workplace. I don't believe that there is a black and white rule on face masks or no face masks, but we do have to provide appropriate cleaning and watching out at the workplace for this. With respect to what we can do with an employee who does not wish to come to work, that is an evolving area, and we get a lot of questions on that. I've got an employee who is not a confirmed case, is not symptomatic, isn't posing a threat. There's no reason to believe this employee can't come to work without posing a threat to anyone else. And there's been no confirmed cases at the workplace, and yet somebody just doesn't want to come into work. And so the answer is, there's probably three different levels of answer here. Number one, there is no black and white prohibition against an employer taking action against an employee in that circumstance. So among the various laws that have come out, there is not yet something that says that we have to allow people to work from home. There's guidance that we should do so if their job duties allow it. But if I've got somebody on the assembly line who cannot possibly do the work from home, and I am in one of the federally designated critical infrastructure sectors, that's a critical qualification, then I can still insist on people coming to work. They don't get a free-for-all on that. So that's the first level, or what I would call the law school answer. The next level, thinking about it, how a plaintiff's attorney would approach it, there's a couple issues here. One of them is the idea that we have a number of stay-at-home orders and shelter-at-home orders in place. And you could have an employee who disagrees with your conclusion that you're in a critical infrastructure and who believes that they're fulfilling their legal obligations by staying home. If I read Governor Newsom's order, I don't think I'm in one of the 16 enumerated public sectors, and I feel that this order is telling me to stay home. And you're my employer, and you say, no, really, we are critical infrastructure here, and you've got to come in. And I say, no, I could very well be covered by Labor Code Section 1102.5. I could very well be exercising what I think is a legal right or protesting against my employer forcing me to do something illegal, and I could state a claim that any termination or discipline violates public policy. The other issue that pops up here is OSHA. There are OSHA standards and labor code sections that enforce them that allow somebody to absent themselves from work if they think they're being exposed to an unsafe environment. Usually that comes up when somebody's being asked to do something in a vault or an unventilated place, or someplace where there's an obvious hazard. But that could certainly be stretched to include this scenario. So just because there's no law that says thou shalt not fire somebody for staying home doesn't mean that they can't come up with an argument. And I think there's going to be a wave of litigation over who did and who didn't fit within these critical infrastructure sectors. And if you ordered people to show up at work and fired people who didn't because you thought your business fit and they don't think it does, you could be in for a good amount of litigation on that. And then you get to the third level, and Amy and I have both alluded to this. This is not a legal analysis. This is a kind of a gut or business analysis. A lot of our clients and a lot of employers are really trying to cushion the blow on employees. And even though 99-point-something% of our cases in litigation settle or get thrown out, if you ever do find yourself in front of an arbitrator or heaven forbid, a jury on this kind of a question, and they don't think that you're showing appropriate support or appropriate, tolerance or leeway for somebody who's, maybe they've got little kids at home or aged parents at home, and they don't feel like coming in and exposing themselves, and you took a hard line. That could be a very, very tough case to defend. So, short answer is, yeah, you can insist on your attendance standards. Second answer is look carefully to make sure there's not a protected protest versus safety or health issues there. And then third level is, I don't know how much sympathy you're ever going to get for taking a hard nose on people in this kind of setting. So I think we've covered that employee relations part. Let's jump forward to the next section then. I think these are just kind of the miscellaneous or other business issues, Amy.
All right. Couple of other things for you to think about outside of the tax-related issues and the employment-related issues are, well, Jeff just talked a little bit about it. Essential critical infrastructure. Are you? Okay, hopefully you can hear me. There we go. Are you?
We can hear you.
Are you a part of the essential critical infrastructure? So just backing up one step, a few days ago, Governor Newsom entered his statewide order to shut down unless you operate in an essential critical infrastructure sector. The guidance on that, someone asked this question, so I'm going to give the website. The guidance on that can be found at this website. COVID-19.ca.gov. And then from there, you'll click on Executive Order, and then you'll see a link for Essential Critical Infrastructure Workforce. This is a new document. If you looked at this a few days ago, this document wasn't there. So you have your federal critical infrastructure sectors, and then there's a document now that makes clear that not everyone who works within those sectors is in the essential workforce. So you need to look at that document. If you think you're in a sector that allows you to continue your business operations publicly and have your employees come in, you need to look at that document for further guidance on who falls within that workforce. For people who aren't part of the essential workforce, they should be sent home for remote work or not working at all if they can't do remote work. So you need to look at that document. It's really important. Other things that you might want to think about: business interruption insurance. General commercial liability policies, general business policies often contain business interruption insurance clauses. They're very, very fact specific. Some of them will cover this and some of them won't. Some of them have exclusions for pandemics. But depending on how that is worded, you might have insurance coverage. consult with your insurance attorneys or your brokers. You should tender a claim even if you think that you don't have it. Let the insurance company reject you. At least you've covered yourself. You may have certain contracts that you that require performance, and those contracts might be subject to defenses. There's a concept of force majeure. There's often a force majeure clause in contracts that relieves parties from meeting certain obligations when there are circumstances outside of their control. Also, you have common law defenses to performance, such as impossibility, or impracticability of performance. Those things might be available to you. So if failure to perform on a contract is going to cost you a lot of money, you may want to talk with, with an attorney your business attorney to get some guidance on that issue. If you can assert these defenses, sometimes you need to assert certain defenses, in writing by a certain time. So you want to take care, mind your other business while all this chaos is going on. There's also some play out there with evictions. A lot of cities and counties are prohibiting evictions. Right now, all the guidance I've seen relates to residential. I haven't seen anything on the commercial side. That doesn't mean it's not out there. This is not my area of the law. I'm just calling your attention to it. So, you might not, and if you're a property owner, you might not be able to conduct an eviction right now. You need to see what the orders in your city or county are. And the governor has already said this is going to be on a citywide or countywide basis, not a statewide basis at this time. We actually, on our website, we have some guidance on evictions. You can look on the Payne Fears website under our COVID-19 resources. I think there's a list that's pretty current of all the cities and counties that have issued orders. And, and then obviously you want to think about how this affects your taxes. And I know if you're on this call, you've got excellent tax professionals helping you with that. And with that, I think we're done with our presentation for today. Please, for some additional, more detailed information, feel free to look at our COVID Resource Center. We have a lot of this stuff is written out and readily available for you.
So I know we've gone over, it's about 10:10. I know we had a ton of questions come in, and many of you panelists have been answering them personally. Is there anything, do we have time for a few questions? Is there anything you feel you need to address right now? Amy, Jeff, or Mike?
Yeah, let me just jump in on a couple. I'm kind of scrolling through the questions here, and I think we did cover some, but there's a couple really quick answers. One is, do we have to submit an application? If we're an employer, we want to do the work sharing program. We want to get our employees access to unemployment while they're just part-time. Do we have to apply? Yes, we do. California EDD maintains a website. You can go onto the EDD website, search for a work sharing plan. They've got all the forms right there for you to fill out and submit, but you can't just do it yourself. You've got to fill in that form. The other one that I think is a quick answer, and this, I mean, this opens a whole can of worms, but the super quick answer is somebody asked, okay, with the WARN Act and the Cal-WARN Act out there, what if my employees are at will? And throughout all these issues that we're talking about, it's important to keep the various laws distinct and think about them each separately. Cal-WARN and WARN apply to employees. It doesn't matter if they are union employees under a collective bargaining agreement or pure at-will employees of a private employer with the best at-will language in the world. It applies to employees. And keep in mind, Cal-WARN and WARN do not prohibit you from firing somebody. They have nothing to do with whether or not you can lay somebody off. They have everything to do with the idea that you have to give them notice of the layoff. And so if I gave the wrong impression there, I apologize. But the WARN and the Cal-WARN Acts do not prohibit you from terminating or laying off employees. They simply require that if you do, you give notice. Those are the two that I saw in the list of questions there that I wanted to jump on quickly. Amy, I don't know if you had any others or Mike.
Well, someone asked about salespeople with commissions on the work share program. I'm not sure if they're exempt. I'm not sure how that would really be possible. I think that's a very fact-specific inquiry, though, and salespeople are classified in different ways. You need to be very careful when you're doing anything with your exempt personnel, and I would consult with your attorneys on that. What do we do with employees who want to stay home as far as pay? You can offer all of the, if they can work remotely, they can work remotely. That's, awesome for them and probably for you too. You can offer them to use any of their available accrued paid time off. And, then lastly, if you just have someone who won't come to work and there's no remote work for them, then you have to consider, whether you just keep them on, without work, or whether you proceed to some of the other options that we talked about, termination and things like that. And that's going to be also highly fact specific. Yes, employers are on the hook to pay the emergency sick leave. Someone asked that, but that is subject to a tax credit. It's a cash flow issue though, for sure.
Amy, we have a question someone wanted to address, the SBA loans. Mm-hmm. So I'm going to have Mike jump in on that. Well, the reason we didn't elaborate so much is because that's changed since the CARE Act. So Mike, can you just jump in on that?
Yeah, so we got a little bit more information about that coming through. So it looks like that in regards to the SBA loan from the CARE Act, it's going to be expanded to expenditures between February 15th and June 30th. The amount of the loan is limited to the lesser of $10 million or 250% of your average annual payroll. And in regards to the debt forgiveness on payroll, they won't forgive wages paid over $100,000. The loan can be used to include payments for rent, utilities, interest, interest on pre-existing debt during this period, and the amount of the loan forgiveness will include these amounts, but it's limited up to 8 weeks of expenditures ending June 30th. It looks like the interest rate that they're talking about for the loan is 4%. And that isn't forgiven or deferred for it's forgiven or deferred for 1 year and then can be paid back. I'm sorry, the cap on that for the payroll, the percentage was 250% of your average monthly payroll, not annual.
So I think it's a 10:15. We probably should wrap this up. I want to thank all of you so much for coming on. I know there's a ton of information that's literally coming down. From the time we scheduled this webinar just a few short days ago, things have drastically changed. But I do want to tell you from the LSL point of view, we're really excited about the good news that's coming out about this CARE Relief Act. Many of our CPAs were just combing over the language last night, and we're really, really feeling encouraged about what's coming and just the support and the relief that's available. So we encourage you to check out Payne Fears website. They have a COVID resource center, as does LSL. Later today, we will be sending out a cleaned up recorded version of our webinar today because of all of our fun internet and technology challenges. We love technology, but I think when you've got almost the entire country working from home, we certainly are also challenged with some of those, what we'll get through also. And we will send you a link to the slides in that email as well. But we want to thank all of you so much for coming. And please reach out if you need us. We're here from you, and check out our websites because both LSL and Payne Fears are going to be putting out frequent updates as all of this incredible legislation develops. So thank you all so much for coming, and have a fantastic day. Bye-bye now.
Thank you. Bye.